Thank you, Judge. And Judge, these speaking objections are clearly coaching the witness because he's regurgitating.
Your Honor, I object and take offense to that comment. I'm objecting based on the law, and I'm making a record for the court. So I take offense to that comment. It's not the case.
All right. Well, I think we can start with objection, the grounds, and the rule number, and then if I need more, I'll ask.
And I'm going to object. This was covered in the previous hearing, where Mr. Bradley said he had no personal knowledge of the exact text that Ms. Merchant is speaking of and actually used in an attempt to refresh his recollection, and he explained exactly what he's explaining here before the court. So this is repetitive and unnecessary, and so I would object to asked and answered and relevance at this point.
All right. Perhaps we'll get there, but I think first Ms. Merchant has the right to draw his attention to the exact, potentially inconsistent statement.
Thank you, Judge. May I approach him?
So overruled.
This is the text.
Objection, Your Honor. He's already answered that question multiple times today. He said he has no idea the timeline or when it occurred. That was one of the first questions that Ms. Merchant asked.
I didn't ask when. I asked his first knowledge. He testified he has knowledge that they had a relationship. I asked him when he first got knowledge of that.
Okay, so if the question is when did you first get knowledge, I think we can start there.
That was the question. Yes.
Right.
Thank you. Knowledge.
We'll get to the how, Mr. Abadi. So I'll note the objection, overrule it. You can answer that.
I'm going to object to this line of questioning, as he said he does not know when he gained knowledge.
He doesn't know the specific date.
That's fine, Ms. Merchant. I think I'm overruling that. I think we can try to see if he can narrow it down based on goalposts.
Thank you.
Victorization of what Mr. Bradley just said. He just said he does not remember. There's nothing specific.
He doesn't remember the exact date. And I think the question now is to reference it or tie it to maybe some other event that he might remember.
I agree with Your Honor. She asked that specific question. He said he does not remember any specific dates after signing the contract. That's exactly what he just said. This is asked and answered.
I know, and we're getting to the end of it. So, Ms. Merchant, you don't have much more to pull on here. But he answered that last question, so what's your next one?
I'm going to object to relevance at this point as to why we're here today.
Sure.
Judge, he doesn't remember much of anything right now, and so I'm trying to create a timeline to hopefully piece this together.
All right. Well, I'm not seeing really the likelihood that that's going to have any success. I'll let you ask a few more questions, but if he doesn't have a date, then I don't know that you're going to be able to create one today.
Okay. Thank you.
Well, I'm going to object because his testimony a few minutes ago is that he did not recall making that statement.
All right, I'll overrule that. Mr. Bradley, answer the question if you can.
So I'm going to object as to the nature of this line of questioning because the witness has made it clear he was speculating as to how or what he knew. And if it's speculation, it's inadmissible for this court.
All right, but the motivations for his reason for speculating would be admissible, so I'll overrule that.
Thank you, Judge.
I'm going to object. The line of questioning Your Honor directed counsel to explore is where he got the knowledge. He's explored that. He said it's speculation, and he didn't get it from any source other than his own speculation.
Sure.
So
I think we're flushing that out, and I think it's her right to have a little leeway on this if he's an adverse witness.
Objection. Hearsay.
Nathan has testified. It's not hearsay.
It's still hearsay. It's an out-of-court statement being brought in for the truth of the matter asserted. So hearsay.
Judge.
Yeah, this would be for impeachment by contradiction, which would be an exception to the hearsay rule, and admissible as substantive evidence, and the privilege issues are overruled.
Thank you, Judge.
Well, I think you just overruled the privilege objection, but we don't know when he's talking about. So we've already established that December 2018 was the date of the privilege.
Sure, and that's something I covered in the in-camera hearing, and based on what he told me in that in-camera hearing, I don't believe any statements to this effect were covered by privilege.
Same objection, Your Honor.
And that's already been ruled upon.
Objection. Asked and answered.
No, I think that's clarified for a thorough sifting cross. Ms. Merchant.
I'm going to object this for relevance.
Bias. Overruled. Well,
Asked and answered. Relevance.
Yeah. Well, he didn't answer that last question, so overruled.
Why he's looking at it, I'm going to object us to asked and answered. We've been through the fact that he sent him a copy of the motion, whether he specifically said rough draft or not, and then asked about the accuracy. He's explained his answer, and I object to asked and answered. So.
Understood, Mr. Lyon. We're getting there. Overruled for now.
Your Honor, I'm going to object.
I
This is
know.
not his motion. He wasn't the affiant of the motion or verified the content.
Overruled, Mr. Body.
Objection, foundation.
Okay, all right, overruled.
And Judge, I just want for the record, because sometimes the record doesn't reflect where people are looking, and that when I ask a question, Mr. Bradley is looking at Mr. Wade and his lawyer to wait for them to object, and they're clearly interacting somehow in the court. So I just want the record to reflect that, because it wouldn't otherwise.
It's there now.
Objection, that would be hearsay.
Overruled.
Not if it came from Mr.
We
Wade,
don't know where it
Judge.
came from, so he said, how do you know, Mr. Bradley?
Objection, hearsay.
It's not hearsay,
Overruled.
Judge.
Wouldn't be how he knows it, and then you ask the next question.
All right, he's already asked the next question.
Objection, Your Honor, privilege. This clearly covers the time after December 2018 that would be covered by privilege.
Yeah, overruled.
I want to object to asked and answered. He's testified that
He hasn't answered. We haven't heard an answer.
He testified he had one conversation with Mr. Wade in the back of his law office.
No, and his answer may change, so
Tip him
overruled.
off as to how to answer the question.
I'm going to object to relevance.
Overruled.
I'll object to any source as to hearsay.
All right, depends on the source. Overruled.
Objection, hearsay.
Overruled.
I'm going to object as to relevance. He said
Sure.
he did not know, and he actually learned from Ms. Merchant the information.
He said he learned about certain trips from Ms. Merchant.
Okay, you can tie it down, but
Thank you.
we'll
He
see.
had no information about any trips that Ms. Willis and Mr. Wade took. That he learned it all from Ms. Merchant. That was his testimony.
Sure.
Judge, I'm
Maybe
allowed
the conclusion we reach. I think she's going to ask more than one question, though. All right, Ms. Merchant.
And if, Judge, just so we can be clear, if he said more than one version, that's all relevant. We're allowed to talk about the different versions that he's told.
All right, I've overruled the
Thank
objection,
you.
Ms. Merchant.
Why we're here today.
Well, I think this was going to be impeachment of Mr. Wade's testimony. Mr. Wade testified that he had never used anyone else's credit card before.
Your Honor, objection as to speculation as to how he thinks they will react.
I think that goes to the motivations of the witness. Overruled.
Object as to asked and answered.
I think he's drilling down. I think that's a fair question. Overruled.
I'm going to object as it relates to foundation and authentication. It was used to, during the last hearing for the purposes of refreshing his recollection. And it's my recollection is that it didn't refresh his recollection, but I would renew my objection as to asked and answered and cumulative.
Okay. As to foundation on authentication, I think Mr. Bradley has recognized them as texts that he sent and received. So I think I'd overrule on that basis any other objections to their admissibility from any other defense counsel. And seeing none, defense exhibit 26 is now admitted.
Check.
Yeah.
Asked and answered.
All right, understood, Mr. Body. I'm going to let Mr. Sato have a few minutes on this, and we'll go from there. But
Judge, well, I'm sorry. I did answer this. I answered it for Ms.
understood.
Merchant. I stated that I was speculating. The judge, someone objected to the speculation, but this was the exact same language.
All right, well, thank you
when
for
I
that
said
recap,
that I
Mr. Bradley. Mr. Sato is
speculate.
asking the question in a slightly different manner, and I'm going to give him a little bit of leeway to do that. So, Mr. Sato.
Correct.
Objection. Asked and
Overruled.
answered. Calls for cumulative answers.
All right, I'm going to give
asked and
him
answered.
just a little bit. All right, Mr. Stockton. Maybe this is going somewhere else.
As to what he knew that Miss Merchant knew.
No, I'd overrule that.
No.
Mr. Bradley, speculation is kind of a weaselly lawyer word. Let's speak truth here.
Then
You're under oath.
argumentative at this point, Your Honor. Not after relevant questions.
Mr.
Let's find
Bradley,
a question, Mr. Rice.
Objection asked and answered twice.
I don't think he's answered it yet.
Objection as to,
All right, overruled.
I'm going to object to speculation.
you knew that, didn't you?
Overruled.
Anything that was objectionable, but these objections are coaching the witness. I asked if he had knowledge. That's it.